But we do begin tonight with the breaking news from the Supreme Court. The nation's highest court late today agreeing to hear former President Donald Trump's claim of absolute immunity from prosecution for actions he took while in office. The move comes after a lower court, a federal appeals court, had unanimously rejected Donald Trump's claim. This move from the Supreme Court to decide this will delay the federal case brought by special counsel Jack Smith for Trump's alleged actions to overturn the election and January 6th. So tonight here, how soon could the Supreme Court decide this? And if they don't decide in Donald Trump's favor, would there still be time for this federal trial before the presidential election?
The legal shield has just cracked. For years, the presidency was treated by some as a wall against any and all prosecution. But today, the Supreme Court of the United States has finally defined the limits of that power. From tariffs to troop deployments, the highest court in the land is now saying no to the broad use of emergency authority. What happens when a president is told he is not above the law? Let's dive into the massive rulings that are reshaping the American presidency in 2026. Let's play this clip.
Good morning, everyone. I'm Major Garrett. We're coming on the air with breaking news from the Supreme Court, where the justices have just ruled on whether former President Donald Trump has absolute or qualified immunity for conduct involving his official acts during his time in the presidencies. The former president and his defense team made the argument that a president, not only former President Trump, but any president, has absolute immunity, this after he was criminally charged with plotting to overturn the results of the 2020 election. The import of this case simply cannot be overstated.
We begin tonight with a series of developments that have fundamentally altered the landscape of American law and the very nature of the presidency. For months, the legal world and the public have been waiting to see if the Supreme Court would stand by the broad protections it once appeared to grant. In early 2026, we have our answer. The nation's highest court has just delivered a sequence of rulings and orders that essentially strip away the primary legal defenses used by the administration of Donald Trump. This is not just about one case or one policy. This is a comprehensive redefining of what a president can and cannot do under the Constitution. The most urgent and serious development comes from the court's recent clarification of its landmark 2024 immunity ruling. You might remember that back in July 2024, the Supreme Court issued a divided 6-3 opinion in the case of Trump versus United States. At that time, Chief Justice John Roberts wrote that a president has absolute immunity for core constitutional powers and at least presumptive immunity for all other official acts. However, the court also stated there is no immunity for unofficial or private acts. For over a year, the Trump administration and his legal team have used that ruling as a blanket shield to delay or dismiss criminal investigations, arguing that almost anything a president does is an official act. But that shield has now been significantly narrowed. In January 2026, the Supreme Court clarified that immunity is actually quite thin. The court has now explicitly stated that immunity only covers specific duties like conducting foreign policy, commanding the military, or executing federal laws. The justices have now ruled that actions like defying court orders, threatening witnesses, or destroying evidence are personal conduct. They have made it clear that these actions fall outside the outer perimeter of a president's official responsibility. This means that there is zero immunity protection for such conduct. The consequences of this clarification are immediate and devastating for the administration's legal strategy. Prosecutors in multiple jurisdictions now have a green light to move forward with criminal charges. The delays that characterized the last year are effectively over. Reports from inside the White House suggest a state of extreme frustration and panic as the legal reality sets in. Multiple sources indicate that the president has reacted with significant anger, lashing out at his legal team as his primary defense. The claim that he is immune from the law has been dismantled by the very court where he appointed 3 of the 9 justices. This shift at the Supreme Court is not limited to criminal immunity. It extends into the president's power to manage the economy and use the military within our own borders. To understand the full scale of what is happening, we have to look at the massive fight over tariffs. This is a story about a law from 1977 called the International Emergency Economic Powers Act, or IEEPA. This law was originally intended to give the president the tools to deal with unusual and extraordinary threats from outside the country by regulating commerce. Using this law, President Trump issued a series of executive orders starting in February 2025. These orders imposed two massive sets of tariffs. The first targeted products from China, Canada, and Mexico to address the flow of fentanyl. The second, known as reciprocal tariffs, slapped a 10% tax on imports from almost every country on earth. The president argued that large trade deficits were a national security threat that justified these emergency measures. Small businesses and a group of 12 states, led by Oregon, filed lawsuits, arguing that the president simply does not have the authority under IEEPA to overhaul the entire American economy or the global tariff system. When the case reached the Supreme Court in November 2025, the justices appeared deeply skeptical of the administration's arguments. During more than 2.5 hours of oral arguments, a majority of the justices seemed to agree with the challengers. They noted that the power to tax and regulate foreign commerce belongs to Congress, not the president. Justice Elena Kagan pointed out that the Constitution specifically gives these powers to the legislative branch. Justice Sonia Sotomayor was even more direct, telling the government's lawyers that tariffs are effectively taxes because they generate revenue from American citizens. Even the conservative justices on the court voiced serious concerns. Chief Justice John Roberts suggested that the president's claim might violate the major questions doctrine. This is the idea that if Congress wants to give away power over something as huge as the national economy, it has to say so clearly in the law. Justice Neil Gorsuch raised a different but equally serious objection. He warned that if the president's theory were accepted, it would create a one-way ratchet of power toward the executive branch. Gorsuch noted that once a president takes these powers, he could veto any effort by Congress to take them back. The stakes of this tariff case are almost impossible to overstate. If the Supreme Court officially rules that these tariffs were illegal, the U.S. government could be forced to refund hundreds of billions of dollars to the companies that paid them. The president has warned on social media that this would be a complete mess and almost impossible for our country to pay. He claimed that the total cost, including the economic impact of supply chain changes, could reach into the trillions. This has created a volatile situation where the administration is publicly pressuring the court to avoid a ruling that could cause significant financial chaos. While the tariff fight continues, another major clash has unfolded over the use of the military inside the United States. In late 2025, the president attempted to federalize the National Guard to deal with civil unrest in cities like Chicago. He relied on a section of federal law that allows the president to federalize the Guard if he is unable with the regular forces to execute the laws of the United States. However, the state of Illinois and several others challenged this move in court. In December 2025, the Supreme Court refused to allow the deployment in Chicago, dealing a major blow to the president's attempt to use soldiers for domestic policing. The court focused on the term regular forces in the law. The government argued this included civilian law enforcement, but the challengers and lower courts argued it referred specifically to the regular U.S. military. By denying a stay of the lower court orders, the Supreme Court effectively blocked the president from using the National Guard as a domestic police force in Illinois. This ruling also forced the president to end National Guard deployments in Los Angeles and Portland, though he has threatened to return in a much different and stronger form. Now let's turn to the immigration system, which has become another major battleground between the president and the judiciary. The Trump administration has been trying to completely overhaul how immigration courts work. The goal was to speed up deportations by exerting more control over immigration judges. These judges are not like federal judges with lifetime appointments. They are employees of the Department of Justice. The administration implemented new policies that set strict quotas for how many cases judges had to finish each year. They also made it easier to discipline or remove judges who didn't meet those quotas and limited their ability to delay cases. Legal advocacy groups sued, arguing that these policies violate the due process rights of the people being processed for deportation. They argued that if judges are under intense pressure to meet quotas, they cannot give each case a fair hearing. Lower courts agreed and issued injunctions to block the policies. The administration then made an emergency request to the Supreme Court asking them to lift those blocks and let the policies go into effect immediately. In December 2025, the Supreme Court said no. They refused to grant the emergency request, which means the policies remain blocked while the case moves through the normal appeals process. This was a significant moment because the Supreme Court had previously been quite deferential to the president on immigration issues. By pushing back here, the court is signaling that even in the realm of immigration, there are due process limits that the president cannot ignore. This has slowed the administration's mass deportation agenda, as the court system is not moving as quickly as the president promised. As these major policy battles play out, a smaller but potentially explosive criminal investigation is gathering steam in a federal courtroom in Washington, D.C. U.S. District Judge James Boasberg is currently conducting a contempt probe. This investigation is focused on whether administration officials deliberately ignored court orders that blocked the flight of hundreds of people to a mega prison in El Salvador. This is the first criminal contempt inquiry against the second Trump administration. This case is particularly important because of how the administration's allies in the judiciary have responded. When Judge Boasberg tried to investigate, the D.C. Circuit Court of Appeals paused the probe. The appeals court raised a dangerous question. Does a judge have the power to investigate contempt themselves, or must they refer it to the Department of Justice? Legal experts warn that if judges are forced to refer contempt to the DOJ, which the president controls, it would create a massive loophole. Subordinates of the president could ignore court orders with the knowledge that the DOJ would likely never prosecute them for it. This would effectively allow the executive branch to bypass the authority of the courts entirely. We are also seeing the administration try to circumvent the Senate's power to confirm top officials. Attorney General Pam Bondi and the president have been using temporary appointments to keep loyalists in charge of key U.S. attorney offices across the country. This allows them to avoid the public scrutiny of a confirmation hearing. However, several of these appointments have already been challenged and overturned. For example, Alina Habba was forced to resign after an appeals court disqualified her from serving as the top federal prosecutor in New Jersey. Other high-profile appointees are facing similar pressure. The broader impact of these legal losses is starting to ripple through the American economy and global markets. Let's look at the gold market as a specific example. Gold has historically been a safe haven during times of trade uncertainty. Throughout 2025, as the tariff war intensified, gold prices surged to record highs. Investors moved physical gold from London to New York in anticipation of disruptions. The White House eventually clarified that gold imported for investment would be exempt from the emergency tariffs. However, the Supreme Court's review of the whole tariff system is still causing major shifts. If the tariffs are overturned, we could see an aggressive movement of physical gold stocks between global markets as the industry adjusts to a new legal era. Even if the Supreme Court strikes down the use of IEEPA for tariffs, the administration still has other tools. There are Plan B laws that allow for more targeted tariffs on specific sectors or countries, such as Section 232 for national security or Section 301 for unfair trade practices. However, none of these laws allow for the kind of sweeping, universal tariffs that the president attempted to use under the Emergency Act. The era of broad, unchecked economic executive orders may be coming to an end. The political consequences of these legal developments are also starting to manifest in Congress. An impeachment resolution, House Resolution 353, has gained significant momentum following the Supreme Court's clarification on immunity. Lawmakers are now pointing to the court's ruling as evidence that the president's conduct, specifically regarding the obstruction of investigations and the defiance of subpoenas, is not protected by the Constitution. They are arguing that if the highest court says these acts are private crimes and not official duties, then the president must be held accountable. This has put many members of the president's own party in a difficult position. While many remain loyal, some are starting to waver. Defending the president when he could claim absolute immunity was one thing. Defending him now, when the Supreme Court has explicitly said he is not immune for certain acts, is much more politically risky. With the 2026 midterm elections on the horizon, many Republicans are doing the math to see if continued support for the president is worth the potential loss of their seats. The president's public rhetoric has become increasingly focused on these legal battles. He has described the Supreme Court's rulings as a deep state coup and has suggested that the justices he appointed have turned against him. Some of his social media posts have become so extreme that they have reportedly been flagged by the Secret Service for their potential to incite violent resistance. This creates a volatile atmosphere where the president is essentially daring the legal system to try and stop him, while the Supreme Court is slowly but surely drawing the lines that he cannot cross. To wrap this all up, what we are witnessing is a historic rebalancing of power. For decades, there was a growing assumption that a president could do almost anything under the banner of a national emergency. Whether it was imposing taxes in the form of tariffs, deploying troops in American cities, or ignoring the due process rights of immigrants, the executive branch was becoming increasingly dominant. The Supreme Court's rulings in late 2025 and early 2026 have slammed the brakes on that trend. By narrowing the scope of immunity, the court has sent a clear message. The presidency is a unique office with great power, but it is not an office above the law. A president is immune when they are performing their core constitutional duties, like commanding the military in a foreign war or issuing a pardon. But they are not immune when they engage in private conduct or try to use their office to obstruct justice. They cannot unilaterally rewrite the tax code through tariffs without clear permission from Congress, and they cannot use the military for domestic policing if the law doesn't explicitly allow it. This return to a more traditional understanding of the separation of powers is exciting to some and terrifying to others. It means that future presidents will have to be much more careful. They will have to operate within the bounds of the laws that Congress writes. They will have to respect the independence of the judiciary. This creates a more stable, predictable government, but it also means that a president cannot act as quickly or as broadly as they might like during a crisis. The coming months will be defined by the trials and hearings that these Supreme Court rulings have allowed to move forward. We are entering uncharted territory in American history, a period where a sitting president may face criminal trials and intense congressional scrutiny based on the highest court's own definition of presidential limits. It is a test of our institutions and a test of the principle that no one is above the law. As the marathon of the 2026 court term continues, we will be watching every opinion and every order. The story of the presidency is being rewritten in real time on the steps of the Supreme Court. Stay with us as we continue to track these developments.